NASCAR is currently in serious difficulty as a result of the lawsuit filed against them. A few weeks ago, 23XI Racing and Front Row Motorsports filed an antitrust case against NASCAR. The plaintiffs were dissatisfied with the way NASCAR had ruled the sport and forced the teams to sign the new charter agreement for next year. NASCAR, however, remains unimpressed and refuses to bend. In reality, they are striking back by throwing a bombshell on 23XI and FRM. NASCAR has replied by rejecting 23XI Racing and Front Row Motorsports' demands for a preliminary injunction. If the court grants the injunction, the teams will be able to sign the charter agreement without having to follow the part that forfeits their antitrust claims. NASCAR's legal staff prepared a 15-page response to the request for a preliminary injunction. There are redactions in the paper on specific details pertaining to the 2025 charter agreement. Here is a summary of NASCAR's case. The document refers to the bottom line up front as follows. Plaintiff's motion, an attempt to force NASCAR into a contract on plaintiff's preferred terms, falls far short of meeting the demanding standard required for obtaining a mandatory injunction. The motion seeks to change the status quo, not maintain it, is about money, not irreparable harm, and fails to show a likelihood of success on the merits. This lawsuit is not about protecting competition. It's a bid by plaintiffs to secure more money than they could through arm's-length negotiations. The motion should be denied. So far, NASCAR has argued that this is primarily a means for 23XI and Front Row to generate more money and obtain better contractual conditions. They also claim that this undermines the status quo. Finally, they do not feel that 23XI and Front Row will win in this matter based on the information offered in the original claim. Of course, NASCAR will do all it can to finish this quickly. They aim to avoid any form of discovery, as well as court, during this process. This answer to the request for a preliminary injunction demonstrates as much. Both parties have referenced an extensive body of legal precedent. This will depend on how the court evaluates the case and the merit of both arguments. There is little doubt that stock car racing functions very differently than most other professional sports. As a result, this case will most likely differ from past ones. While we haven't heard anything from the court, 23XI and Front Row seek a verdict on the preliminary injunction by November 1st, so we could be near. Do you believe the court will side with the teams or NASCAR? NASCAR's immediate worry is that some information may become public as a result of this case. If this information, along with the court records, becomes public, NASCAR will lose nearly all control of its operations. As a privately held organization, NASCAR has always chosen to keep key financial and operational facts hidden from the public. This strategy enables the organization to keep strict control over how its business choices are portrayed, therefore safeguarding proprietary information and sensitive financial arrangements, such as its revenue-sharing model and contracts with racetracks, teams, and media partners. NASCAR's demand for solitude stems in part from the company's unusual structure, which allows the France family to keep major influence. The current lawsuit filed by 23XI Racing and Front Row Motorsports has raised worries among NASCAR officials concerning public disclosure. The teams have filed petitions asking access to internal discussions and records that might disclose how NASCAR's leadership handles critical areas of the sport, including as the contentious charter system. NASCAR is likely to keep such information private in order to avoid exposing the inner workings of its economic model, which may attract scrutiny from the public, competitors, and possibly regulatory organizations. As a private corporation, NASCAR is not obligated to publish financial statistics to the same extent as publicly listed firms, allowing it to operate privately. This secrecy enables it to make choices free of shareholder pressure or public opinion, which may be helpful for long-term planning, but raises questions about transparency, particularly when conflicts emerge between teams and the governing body. In this action, NASCAR's goal to avoid public disclosure of sensitive records may be motivated by a worry that such discoveries could damage its legal defense or disclose potentially controversial behaviors inside the sport. If compelled to reveal such information, NASCAR may suffer a public relations crisis, and competitors may acquire insights into their business tactics that they may use against them. Thus, keeping its private status is critical to NASCAR's control over its operations and competitiveness. If critical internal NASCAR material gets public as a result of the dispute with 23XI Racing and Front Row Motorsports, it may have far-reaching implications for both the company and the sport. The disclosure of secret financial, contractual, and operational data might result in substantial changes in how NASCAR is viewed, operated, and governed. The public exposure of private financial agreements, such as revenue-sharing arrangements with teams, sponsors, or media outlets, might damage NASCAR's competitive edge. Teams or sponsors may use this information to negotiate better conditions, while competitors in the motorsports business may use the data to create competing series or events. Furthermore, other teams may begin to question their agreements, demanding greater transparency or equality in how NASCAR controls its money streams. Internal communications that disclose unethical company practices, monopolistic activity, or favoritism could lead to requests for additional scrutiny from governing bodies or regulatory authorities. NASCAR has had some autonomy as a private organization, but this might change if the papers reveal antitrust infractions or other legal problems. This type of disclosure might result in formal inquiries, which could lead to litigation from other teams or stakeholders who believe they have been harmed. NASCAR's ties with teams, sponsors, and track owners may be compromised if private agreements show unfair or preferential treatment. Teams who believe they have been treated unfairly may demand reforms, while sponsors may reconsider their engagement if they believe the sport is being governed in a way that is inconsistent with their beliefs. This might result in a loss of sponsorship money, which is an important component of NASCAR's financial strategy. The publication of internal data may harm NASCAR's public image. Fans who realize that the sports administration processes are not as transparent or fair as they had assumed may lose faith in the organization. If NASCAR is seen to prioritize money or specific teams over the integrity of the competition, viewership, ticket sales, and general fan involvement may suffer. Finally, the consequences of such public revelations may drive NASCAR to make substantial operational adjustments, potentially leading to revisions in how the sport is controlled, teams are handled, and profits are allocated. It might also call into question NASCAR's private, family-controlled economic model, possibly changing the sport's future. In the ongoing legal struggle between NASCAR and the plaintiffs, 2311 Racing and Front Row Motorsports, all parties have agreed to redact sensitive material from the legal filings filed with the court. This judgment shows a recognition that some facts, particularly those relating to proprietary business processes, financial arrangements, and internal communications, must be secured to avoid possible harm to both NASCAR's and the team's economic interests. The agreement to redact sensitive content permits the legal processes to proceed without disclosing proprietary components of NASCAR's operations, including as information regarding the charter system, sponsorship agreements, or media rights. Both sides presumably saw the value in keeping this information private, since public exposure may harm relationships with sponsors, media partners, and other teams in the sport. Furthermore, redaction safeguards trade secrets and confidential data that may otherwise be abused by rivals or misconstrued by the public. By redacting sections of the papers, NASCAR avoids the risk of creating a precedent that might require the company to divulge internal activities more extensively in future legal proceedings. This arrangement allows the plaintiffs to submit their points without risking their status in the NASCAR environment. The censorship of sensitive information in the legal filings for NASCAR's complaint against 2311 Racing and Front Row Motorsports will have no effect on the overall case because all required parties, including the court, will continue to have full access to the unredacted files. Redactions are used to keep proprietary or sensitive business information from becoming public, but they do not prohibit the judge, legal teams, or court officials from studying the whole document confidentially. The courts will consider all available information, including sections that have been withheld from public papers, to ensure that the action progresses fairly and that both sides may adequately present their points. While redacted copies of documents are made available to the public to protect privacy and sensitive company processes, these redactions do not limit the court's ability to make a decision based on all relevant facts. To succeed, 2311 Racing and Front Row Motorsports must demonstrate that NASCAR's policies violate antitrust laws by limiting competition or damaging the market. This is a difficult legal threshold to fulfill, especially given NASCAR's claim that the charter structure assures the sport's economic survival and competitive fairness. Courts often seek concrete proof of monopolistic activity that affects consumers or rivals, and demonstrating that NASCAR's system exceeds that line may be challenging. While both sides make compelling points, NASCAR's defense may have an advantage since it can argue that its system has been in existence for years with the cooperation of teams, making it less likely to be perceived as an illegal monopoly. Furthermore, courts frequently prefer private corporations in such disputes, unless substantial proof of anti-competitive harm is presented. However, if 2311 and Front Row Motorsports can demonstrate that NASCAR's practices severely limit team expansion and impede competition, they may gain momentum. Ultimately, the outcome will be determined by how well the teams explain their case and whether the court sees NASCAR's charter structure as a legitimate economic plan or an anti-competitive tactic. Who do you think will come out on top in this antitrust case? Share your opinions in the comments area below.